Dear friends, in this video let me to discuss the Child Labor Prohibition and Regulation Act 1986, which is a part of labor legislation in India. Friends, we are all have passed our childhood days. Naturally, every child may have his or her own dreams. Dreams may be to play with other childs or to learn in a school. If you think of a condition of a child working in a hotel or working in a factory or working in a hazardous or risky or dangerous industries and getting regular punishment from the superiors or manager or owner of the establishment. We can't think of that type of the condition for a child. Hence, Government of India passed a legislation named the Child Labor Prohibition and Regulation Act in 1986. So the introduction given in the Child Labor Act, it specifies its objectives very clearly. It is given that employment of a children below 14 years. Generally, we consider any child below 14 years, any boy or girl below 14 years is a child. Below 14 years in a certain prohibited employment. It means that there are certain prohibited employment. It is a prohibited for children. Have been prohibited by the various acts. There is a plethora of acts. There are many laws are there, legislations are there. But there is no procedure laid down in any law for deciding in which employment. So, in which employment where child labor is restricted, which employment or which occupation or which job or which process or which industry. These aspects are not made clear anywhere in the different acts. There is also no law to regulate the working condition. What is the working condition to be provided to a child who is working in an establishment? Or what are the facilities or amenities to be provided? It is not clear in many acts. So, what type of the working condition of children or for the children in the most of the employment where they are not prohibited from working? So, in certain establishment, child labors are not prohibited. But the question is that what type of the working condition, what are the facilities, what are the rules and regulation related with their work? It is not very clear. Accordingly, it was decided to enact a comprehensive law, a comprehensive legislation on the subject, and the result is that the Child Labor Prohibition and Regulation Act in 1986. So this act enacted on 23rd December of 1986 and it extended to the whole of India. And this act consists of 4 parts, part 1, 2, 3, 4, like that 4 parts are there and include 26 sections, altogether 26 sections are there. And the act contains a schedule along with that the annexure is that in the form of the schedule, and the schedule is part A and part B. Part A is the list of 18 occupations and they named different occupation like that: transportation, catering services, construction, slaughtering houses, foundries, handloom, powerloom, circus, like that type of the occupations are there in part A. And in part B, it is the list of 65 processes. The processes, BD manufacturing. And it is one of the very common occupation in this district. BD manufacturing is prohibited for the children. Cloth printing, soap manufacturing, cashew nut, it is another major industry of this district. Cashew nut processing, jute industry, fireworks, crackers manufacturing, manufacturing any type of the pesticides, paper industry, textile industry, beverage manufacturing, and so many other. Altogether, there are 65 processes are there. 65 processes are there. It cover this occupation and cover almost all the hazardous or dangerous type of the industries, processes, and occupations and jobs. So the act given very clearly the definition. Section 2, I cover only the important definition and what we consider more important for our purpose and subject. One is that child. As per the section 2 of the act, who is the child? Child means a person, boy or girl, who has not completed his 14th year of age. Those who are not completed 14 years of age is considered as a child. That is a very important aspect we need to understand. Any boy or girl not completed 14 years. So establishment. It is often given that child labor is prohibited in certain establishment. What is the establishment? Section 2 elaborate that establishment include a shop, a commercial establishment, workshops, farm, maybe agriculture farm, sericulture farm, or poultry farm, like that, farms, residential hotels with the boarding facilities. Many hotels are there, and for the cleaning purpose or some other purpose, many times there is a possibility of appointing a child as a labor. Restaurant, hotels, eating house, theaters, or any other place of public amusement, water park, like that, or entertainment, circus, like that, occupations. So all this we can call it is a establishment, an establishment. So in establishment, in the listed establishment, 18 occupations and 65 process. So we can cover it is a establishment. So section 3 given that prohibition of employment of children in certain occupation and processes. It is given that no child shall be employed or permitted to work in any occupations set forth in part A, as I said, 18 occupations of the schedule, or in any work wherein any of the processes, many of the industries following the processes, and 65 processes are there, and it is given in the part B, and it is completely not permitted, and it is banned to employ. So given in the schedule. Whereas there are certain exemptions. So what are the exemptions? Look at here. Provided that nothing in this section shall apply to any workshop wherein any process to the occupation or to process is carried on by the occupier, owner, or to the manager, occupier, with the aid of his family. Suppose if there is a family, small business is that, small industry that, cottage industry that, in that father or to mother, parents giving a small work to the children, it is not prohibited, their own children, so they can give a small work in any that type of the family business or to family industries to the children, or to any school establishment, or receiving, that is by or receiving assistance or recognition from the government. Generally we can see that many times a school teacher give a work to the school children to clean the classroom, to keep the neatness of their surroundings. So in such a cases, giving that type of the work is not prohibited. Or sometimes the school teacher may give a small work of gardening or horticulture or to vegetable growing, for the midday purpose. Many schools, even government school, Jilla Panchayat schools, growing their own vegetable in the school premises, in the school area. So that type of the work, suppose if teachers give that type of the work, it is not prohibited under the Act. So section 5, child labor technical advisory committee is. So central government may constitute the child labor technical committee to advise it. It means that the central government can get advice from the committee. That committee is that child labor technical committee, and appointed by the central government only. And what is the work of this committee? For the purpose of addition of occupation. Now we have certain 18 occupation is that, or 65 processes are there. Suppose if the committee feels that there is a need to add some more occupations or some more processes to the schedule given in the Act, part schedule A and B, in such a cases, so this child labor technical committee can recommend the central government to add new occupations or to processes under the Act where child labor is prohibited. The technical committee consists of a chairman and other members not exceeding 10. It means that altogether the size of the committee is at the maximum level, not exceeding 10 members. Chairman and other 10 members at the maximum. It may be 11 members committee or to less than 11 members committee as appointed by the central government. And these committee members, including the chairman, generally nominated or to appointed by the central government. The committee has the power to regulate the terms and conditions, rules, regulation, privileges, amenities, what are the child related issues are there. The committee has a power to regulate. They can change, they can impose some new rules and regulations, or they may demand to give some more amenities or to the new facilities. So their job is like that only, to regulate the terms and conditions for employment of children where they are not prohibited. Where the child laborers are allowed to work, then the committee generally state what are the terms and conditions should be followed by the employer. So section 7, it is related with the hours and the period of the work. So under the section 7, subsection 1 states that no child shall be required or permitted to work in any establishment in excess of such number of hours as may be prescribed for such establishment or class of establishment. Generally, the Act prescribes what is the number of working hours in a day. For a particular industry, there is a specific number of working hours. Generally, it is a 8 hours. Whereas in coal mines, etc., it may be a 3 hours or to 4 hours, like that only, because it is a very dangerous and it is a very risky. So, and it is harmful to the health. So, it may be a 3 hours, 4 hours, like that. Therefore, to any child, it should not be more than a specific number of working hours in a day. And the second subsection states that the period of the work on each day shall be so fixed that no period shall exceed 3 hours, and that no child shall work for more than 3 hours before he has had an interval for rest 1 hour. It means that so for all type of the work for a child labor, any manager or to owner can give continuously for the 3 hours maximum, and after the 3 hours want to be give a leisure or rest period of 1 hour. So 3 hours at the maximum 3 hours of work, then 1 hour of the leisure, and 1 to 3 hours work. Fourth hour is the leisure, and fifth hour leisure may be work may be continued, not leisure. Fourth hour is the leisure, and fifth hour work may be continued, provided there is a condition in that in the subsection 3. The period of the work of a child shall be so arranged that inclusive of interval for rest, including the rest time, it shall not be spread over more than 6 hours in a day. At the maximum, including the rest time, the working hours, including the rest time, it should not be more than 6 hours in a day. And subsection 4 states that no child shall be permitted to work between 7 p.m. evening and morning 8 a.m. It means that night shift is not allowed for the child labor. It is not permitted. So 7 p.m. to 8 a.m. and in between keep in mind 8 a.m. to 7 p.m. work may be given, but at the maximum 6 hours, including leisure time in between. So we want to be keep in mind. And subsection 5 states that no child shall be required or permitted to work overtime. Many times due to the work pressure, overtime work by workers are very common. Depend upon the work pressure. If there is a more demand for the product, workers may be asked to work overtime. Whereas any manager or to owner not permitted to give overtime work to a child. So section 8 states that weekly holidays. It means that so in the 7 days period, every child should be given a holiday of 1 day. 1 day must be holiday out of the 7 days. It need not be one Sunday, it may be any day. So want to be follow the procedure very properly. And the condition as per the act is that details of the holidays should be exhibited or to displayed permanently in a prominent place of the premises of the establishment. So which day is the holiday for child who is working under him? So it should be made very clearly, and it should be exhibited, it should be displayed in a prominent place. So everybody can have a look at the notice which one is the holiday for a child. So it must be displayed in a proper place. And another condition is that any manager or to the occupier, owner, not allowed to change the notice. Once it is fixed, it should be continued for 3 months. And before 3 months, he is not allowed to change the notice issued by him. So it will be continue for continuous 3 months. Then only he can alter the holidays, maybe Sunday to Saturday, like that. And section 9, notice to inspector. Generally we know it is prohibited, and there are certain regulations. Who is the authority to implement this act? Generally government labor departments are there. And in the government labor department, at the taluk level there is an inspector, at the district level there is a commissioner, labor commissioner, and other officers and staff are there. Every occupier who employs or permits any child to work shall, within the period of 30 days from the date of such employment, once a occupier or to owner or to manager appointed a child labor in not prohibited allowed industry or to allowed establishment, so within 30 days, send to the inspector, send to the generally labor inspector a written notice containing, and the written notice is that the name and the situation, it is related with the address, the place of the establishment. And along with this name and place, the name of the person in actual management of the establishment. So generally what happening is that many times there is a possibility that owner is separate and the person who manage or to run the establishment may be separate. In such a cases, inspector want to make it very clear. He want to get a very clear information about that the management is in whose hand. It means that who is the controller of a child labor. It should be made very clear for the purpose. The name of the person who is in actual management of the establishment should be included in the notice. The address to which communication relating to the establishment should be sent. So address should be given. And the fourth one is that nature of the occupation or the processes carried on in the establishment, that business or to the firm or to shop or to hotel, what type of the occupation, what type of the services, what type of the process carried, so that detail should be provided to the inspector. So section 10 states that it is related with this dispute as to the age. Many times we know in practically what happening is that labor inspector or to the labor commissioner give a surprise right to establishment to find whether the child laborers are working there. Many times what happening that in practice, in a reality, owner of the shop generally claim that even here the boy looks very small. He claimed that his age is more than 40. Maybe say 16 years or to 7 years. But things may be different. Whereas labor inspector maybe have his own inferences about the age. It may be 13 or to below 14 like that. In such a cases, dispute arises about the age of a child. In such a cases, it must be referred to the prescribed medical authority. And generally prescribed medical authority is any doctors, any qualified doctors, medical practitioners, generally who are working in health department of the government. They are the prescribed medical authority. Generally, he may be a taluk medical officer or to district medical officer or to district surgeon like that. They are the prescribed medical officer. And if any dispute arises, the whatever the certificate given by the medical authority is final. And section 10 related with the maintenance of the register. And the register, it is in the form of a book to be kept in the establishment. And that register generally contain, a register must be kept by the occupier, by the owner or to the manager, made available for inspection. It means that suppose if there is a labor inspector visit for the purpose of inspection, it should be made available, register must be made available. What are the contents of the register? And contents are the name and date of birth of every child so employed there. Name of the child along with the date of birth. Only, remember, only in the allowed occupations and services or to processes. Whereas it is prohibited, it is 100% prohibited and there is no question of register. Where child labor allowed, they want to be keep a register which contain the name and the date of birth of every child. And the hours and periods of the work. And number of hours of the work, 6 hours or to less than 6 hours, at the maximum 6 hours or to 5 or to 6 hours, or to period of the work from 10 o'clock to 3 o'clock like that, or morning 8 o'clock to 12 o'clock like that. The period should be very clearly mentioned there, should be registered in the book. And interval time between 10 and 11 interval, or to 3 and 4 interval like that, it should be made is a more clearly specified in the register. And third content is that nature of the work given to the children, to the child labor. What type of the work is given to the boy or to girl, it should be very clearly specified in the register, or to any other particulars prescribed by the act should be given in the register. And section 13 states certain health and safety measures to be adopted in an establishment. And this health and safety measurement generally given in the Factories Act of 1948 in India. Almost the same health measures and safety measures, safety cares are there. It is related with these health measures, cleanliness, neatness of the place of the work, the place where the child labor work must not be rubbish, and must be freedom from any nuisance. And it means that a peaceful atmosphere must be there. There must be a care about the disposal of the waste. Sometimes chemical waste may be harm the health of a child. Effluent, so solid waste, how they can dispose it. Proper care should be taken. And want to be frame the rules and regulation, and want to be follow that also. Ventilation and temperature. Ventilation, light and air. And temperature, suppose if there is too much cold or too much heat, it harm the health of a child. So in such cases, want to be maintain a proper temperature. It is the duty of the occupier to give a conducive atmosphere of work to a child. It must be free from the dust and fumes. Artificial humidification, and maybe suppose if there is no humidity in the air, it may be lead to this suffocation, or too much dry of the skin. So for the purpose, artificial humidification arrangement should be made by the owner of the establishment. Lighting, too much glaring or too much darkness may harm the eyes of a child. Drinking water should be provided. Toilets and bathrooms, washroom facilities must be given. Spittoons must be provided. Fencing of machines. So many times generally in factories, gigantic or big size of machines are there running with the big wheels, turbines like that. Many times there is a possibility that it may be dangerous to a child working there. So proper fencing, guard must be there. Cover must be there to the various machines, especially belt like that. Movements, a particular set of movements only allowed, and it means that where the child labor not allowed to enter must be specified. The child must not enter any restricted area, because it may be a more risky or to hazardous to health of a child. Care to be taken near dangerous machine. It is a continuation of the previous point. Devices for cutting power. Many times accident will be take place in industry. In such cases, to prevent further damage, immediately want to be disconnect power or to electricity. So for the purpose, the devices to cut the power must be in a place which is accessible to anybody. to cut the power. So proper arrangement must be made. Safety of floors, many times slipping. Steps, slipping steps, maybe injure a child. So care must be taken. Sumps, open places. Tanks like that, sumps, tanks, openings in the floors should be avoided, and protection of eyes, especially welding shops like that, where there is a glaring in that, wants to wear goggles to protect the eyes. So this type of the safety and healthy measure must be followed. Section 14 of the Act related with the penalties. So it states that if any occupier violate or in contravention of the provision of the Act, employ or appoint or to give work to any child, it is punishable not less than 3 months, and punishment may be go up to the 12 months, 1 year, or may be fined. 10,000 rupees is the minimum, not less than 10,000 rupees. Fine may be to the extent of 20,000 rupees. So imprisonment is there, or fine is there, or if magistrate thinks so, maybe both imprisonment as well as fine. So one more thing is that generally we know the child below 14 years, not completed 14 years, prohibited to work in certain occupations or processes. Whereas according to the Mines Act of 1952, no person below 18 years of age shall be allowed to work in any mines. So for the purpose of the mines, as per the Mines Act, 18 years is the minimum age limit to give the work. Want to be cross 18 years, then only a child or a person may be appointed in mines for work. Section 16, it is the procedure relating to offences. So procedure relating to offences. Any person, any public, you or I, public or police officers, generally who keep law and order in the locality, who finds in certain establishment a child labor working or some child laborers are working, or inspector, labor inspector or inspector of the concerned department may file complaint of the commission of an offence under this act to any court of competent jurisdictions. So any person is have the right to approach the court against the person who appointed a child labor, who committed offence, who violated the provisions of the act. So this is the given. And the second one is that every certificate as to the age, as I said, many times a dispute arises about the age of a child, and it is given that the age prescribed by the medical authority is the final evidence, and once medical officer certify this is the age of a child, that is the final, and it is the final evidence, and it is accepted by the court, appropriate court. And no court inferior to that of metropolitan magistrate or a magistrate of the first class shall try any offence under this act. It is with regard to the qualification of the magistrate or to judicial officer who can inquire and ultimately give a final verdict related with this child labor issues. Its qualification is that metropolitan magistrate or to magistrate of the first class level should be handle this type of the subjects. And some more additions are there. And here I am not covered all the sections of the act. Altogether there are 26 sections are there, and here I covered all the important sections which is very important from examination point of the view. And some more addition is that it's a recent development is that. So now if you look at the shops or to the factories, many times we can see the board. The board is that we are not appointing any child labor in this establishment. Often we can see a notice in front of the hotels or to shops or to factories. And this is as per this Child Labor Act. It is a recent amendment, and it is one of the requirement for establishments coming under the act where child labor is prohibited want to be display that type of the board or display notice in front of their premises. And one more thing we want to be know that in Karnataka there is a Shop and Commercial Establishment Act. It is enacted in 1961, and many of the provisions given under the Child Labor Act of 1986 drawn from that act. Almost these are the resembles, and according to that act also, no child shall required or allowed to work in any establishment. In any establishment. And once again they given the list of the different establishment, and more particularly it is stated that in any establishment. So it is prohibited, and all this to protect child from the rigorous work at the early childhood, and it is to prepare a good citizen for the country. So this is the end of this video, and I will come with one more video on Apprentice Act. Until then, goodbye to you.